How can you stop the police from snooping around your property? I'm going to give you the 4 rules you need to know in order to protect your home and your private property from the prying eyes of the police. We've all seen cops do this. They think they see something suspicious on your property, and now they believe some type of criminal activity may be going on. So what do? They decide they're going to start walking around your property. Maybe they walk up to your front porch, start looking through some of the things on your porch. Maybe they start looking through your windows and maybe even walk around to your backyard. Is there a limit to this? Yes, there is. In fact, this is one of the most common areas I see police become confused about the law because they think that if they see something suspicious or they think they can just walk up and start looking around your front porch, they can investigate whatever they want as long as they don't come into your house. In reality, courts give us some guidelines so that you can know your rights and protect your privacy so that you can stop police from snooping where they have no authority to be. Let's say cops approach your front yard and they want to start snooping around. Can they legally do this? It really depends, because we must first take a look at the difference between curtilage and open fields. I know, strange legal terms that no one uses anymore, but it's important that we know the difference. So before I get into what curtilage is, let's first identify what courts have called open fields. When we talk about an open field, are we talking about a big green pasture? Not necessarily. Courts have defined an open field as an undeveloped area outside of the curtilage. This area is still your private property and maybe even a part of your property you use all the time, but it is an area that courts have designated as being less intimate to the use of your home, as opposed to, say, the front porch swing, or maybe you've got a rocking chair on the front porch, or you've got a barbecue grill, or something along those lines. This area is usually detached or removed from your main home. In fact, this brings us to the case of Oliver versus US. In this situation, the police had actually received an anonymous tip that Oliver was growing a marijuana farm somewhere on his property, so the police showed up wanting to search. As the police drove up the road towards Oliver's Kentucky farm, they noticed several no trespassing signs. And when they made their way up to the actual gate, they noticed that the gate was locked and a no trespassing sign was on the front of the gate. Cops simply walked around the gate, ignored the no trespassing signs, and made their way several hundred yards into the property. Once they made it into the property, they actually found a barn and a camper. They started to look around a little bit, and wouldn't you know it, around the other side of the barn, they found a field full of marijuana. Now, this field of marijuana was more than a mile away from Oliver's primary home, and the cops admitted that this was an area that was very secluded, surrounded by woods, and could not be seen from any public access point. The Supreme Court ruled that even though Oliver had taken the time to put a no trespassing sign up, lock his gate, and seclude the marijuana from public view, the court said that that was not enough to protect him from the police. In other words, the Supreme Court ruled that there is no expectation of privacy in an open field. For you, that means courts allow police to snoop around any open property area that is considered an open field because they believe you have no reasonable expectation of privacy. Now, we figured out what an open field is. What exactly is curtilage? The court has defined curtilage as, quote, the area of your property in which the intimate activity associated with the sanctity of the home and privacies of life take place. The only way to understand what curtilage is for us to first understand what is necessary for a cop to search your home. Now look, under the 4th Amendment of the United States Constitution, in order for a police officer to actually search your home, they must either have a valid warrant, or a consent from the homeowner, or number 3, what's known as exigent circumstances, which is some type of emergency situation that would allow them to make a warrantless search or entry. Now, I cover these areas in much more depth than some of my other videos, but it's important to understand, unless the cops either have your permission, your consent, or a valid search warrant, or some type of emergency circumstances, cops cannot get into your home. Now, when we're talking about curtilage though, instead of you thinking about the inside of your home, I want you to think about the areas immediately surrounding your home, very close to your home. Maybe your front porch, maybe your back patio area, Maybe areas like where your patio is with your grill, maybe your swing, your front swing, or your rocking chair, or those areas. Can cops now decide to walk up to your front porch or those areas and just start digging around things and searching or looking through your windows? No, they cannot. Cops get confused about this all the time. Here's what the law is. The curtilage around your home has the same Fourth Amendment protections under the law as the inside of your home. But any area that is not considered curtilage is now considered an open field. So we have to ask the question, what exact areas around your home are considered curtilage? This brings us to the case of United States versus Dunn. In US versus Dunn, Dunn had a 100-acre ranch. The police were actually able to obtain a search warrant by actually hiding a GPS tracker device in drug paraphernalia, and it tracked it down to Dunn's ranch. The cops then made a warrantless search on the property by first entering into the back side of the property, nowhere near the main home. They then crossed over both exterior and interior perimeter fences until they located a few buildings off to themselves. Now look, these buildings were off to themselves on the private property, but they were not visible at all from the main public roads, and no one else would have known they were there. The cops then claimed to smell an odor of chemicals. So they believed that allowed them to ignore the locked gate. They climbed over the gate and they looked inside the barn. Of course, at this time, the police believed they saw something suspicious, so they went to a judge and obtained a warrant, came back and seized both drugs as well as supplies for making drugs. Dunn, of course, was then arrested, and the courts had to decide under the Fourth Amendment whether this was a search for the police to enter on the backside of the property and to go and look inside the actual barn. The court sided with the police on this one and decided that it was not illegal for the police to snoop around the barn. Why? Because the barn, according to the court, was not a part of the curtilage of the property and instead was part of the open field. Now, why does this matter? Because for the first time, Dunn actually put together a 4-part test to help determine whether or not police are on a curtilage or on open field looking to do a search. Number 1, the proximity of the area being searched to the home. Now, here's the general rule. Let's say the barn is 60 yards or 100 yards away from the home. There, it's more likely to be seen as an open field rather than curtilage. So the further away from the home it is, the more likely the police are allowed to snoop around your area. Number 2, is the area within a single enclosure? Now what this means is it connected to the main home? Are the police looking to search in an area that is within the main fenced area of your yard, of your house? If so, it's much more likely to be seen as curtilage. Now this is big if you live in the city, because for most part, you're talking about small parcels of land. And if cops can't just start coming into the main intimate areas of your home and just looking around your yard and digging on your front porch and other areas, it's a much different picture if you're talking about living out in the country. If you're out in the country and you've got a lot of acreage, there is much more room for the police to argue they are now on an open field. Number 3, what is the use of the area, as the courts call it? Here, this is a big deal. Are you maintaining it? Are you keeping the grass cut? Is this an area where you commonly use? In other words, if it's a rundown, dilapidated barn and there's grown-up weeds all over it and it doesn't look like anybody's been out there in a long time, they're probably not going to see this as curtilage. The key is this area intimately associated with the use of the home? In that situation, it would be considered part of your yard and likely curtilage. The court in Dunn really focused in on the fact that the barn looked dilapidated and it did not look like it was a part of the intimate activities of the home. The problem? The court provided no real guidelines so that the police can objectively determine whether an area being searched is a part of the intimate activities of the home. Number 4, what steps did you take to protect the area from being seen by the public? In other words, let's use the example of the barn again. If it's a run-down, dilapidated barn and you left the front gate open or the front door open and somebody could easily get in there, or there's broken windows, there would be no reasonable expectation of privacy. Another example is, what if a cop is standing on a public road or maybe even across the way and you don't have any fence or maybe just a chain link fence, and he starts peering into your yard and looking around and snooping on you? Is that legal to do? Technically, yes. Under the plain view doctrine, now the officer can actually, from a public roadway, look and see what's going on. However, if you put up an 8-foot or 10-foot privacy fence with a locked gate and a no trespassing sign, the cop now can't just start trying to climb over your fence and look to see what's going on. Now, what if the police want to perform a warrantless search of your car, but your car is parked within the curtilage of your home? Well, the United States Supreme Court case of Collins versus Virginia answered this question for us. Now, here's what happened in Collins. In that situation, Collins was actually driving a motorcycle on a highway and supposedly committed some traffic violations, so the cops tried to pull him over. Well, he evaded arrest and he fled from the police. So then at that point, the detective decided to do a further investigation, and he came to believe that Collins had stolen the motorcycle. So he began to snoop around on Collins' Facebook page. As he looked around on his Facebook page, lo and behold, he found a picture that he thought matched a stolen motorcycle that was sitting right on Collins' front porch of his home. So as a result of that, he decided he was going to drive over to Collins' house. He parked his car, got out his camera, but what did he see? He saw what looked like a motorcycle covered over with a tarp. So he decided he was going to walk up to the motorcycle, pull the tarp off, take some photos to confirm that it was stolen. And after he did this, he decided to walk up to Collins' front door. He knocked on the door, and lo and behold, Collins answered the door. And then Collins admitted that he purchased the motorcycle, but that he never obtained the title. Based upon that information, the detective decided to arrest him. Now, here's what's key about this ruling. The Supreme Court ruled that because the cops stepped onto the curtilage of Collins' home in order to conduct a warrantless search by pulling back that tarp and taking pictures, he violated the Fourth Amendment rights of Collins, because it would have been the same analysis if the detective had tried to come over to Collins' house and search the inside of his home without a warrant. So the Supreme Court ruled 8-1 that it was illegal. So what did we learn from the Supreme Court here? How do we keep cops from being able to legally snoop around our property? First, the area immediately surrounding your home would be considered curtilage and protected under the Fourth Amendment, as long as, number one, it's connected to your home, like within the interior fence of your property and your home, and number two, you keep up that property and maintain it and use it for the intimate activities of the home, like maybe you're playing, maybe you're living, maybe you're cooking and grilling, doing all the things people do close to their home. And then thirdly, you have to make sure and take action to keep it private from the general public. Let's say you put up a privacy fence. Maybe you put up a no trespassing sign, as well as maybe locking the gate. In almost any situation in the city with smaller plats of land, the police are either going to have your consent, a valid search warrant, or exigent circumstances to legally snoop around your property. Now, if you live in the country, don't forget the difference between curtilage and an open field. And remember, any area that's further away from your home is less likely to be considered curtilage, particularly if you do not maintain it. Areas that are considered open fields are open for the police to be able to investigate it without a warrant. So, if the police start searching around the curtilage of your home, you should immediately remind them you do not consent to them searching. You should demand that they leave your property at once and tell them that they are violating your Fourth Amendment rights by searching and snooping around on your curtilage. Remember, if cops violate your rights and search within the curtilage and seize any evidence, your attorney can file a motion to suppress and have that illegally obtained evidence thrown out in court. You have privacy rights for areas surrounding your home. Know your rights and stand up for those rights. Now, what about cops walking up to your front door and knocking on your door? Can they legally do this? That brings us to the infamous knock and talk. Check out this next video where I give you specific tips of what to do if the cops come knocking. See you over there.